All right, so you've probably read about strict scrutiny, intermediate scrutiny, and the rational basis or reasonable relationship test, a rational relationship test. These are three levels of scrutiny. So I have heard it said or put this way: when you have a right and it looks like, or at least the allegation is that the government is restricting that right, and you go to the court for help, for a remedy, this government encroachment or something like, the government is going to have to decide, and that is the judiciary branch, right? Judges. They're going to have to decide how much they care. So the judges are going to have to decide how much they care. They can either care a little bit, or they can care a lot more, and then they can care a lot. Now, if the judges care a lot about this right, typically you're going to have a strict scrutiny test. They're going to hold the government, the government actor, whoever you're complaining about, or whoever the plaintiff is complaining about, to very high standard. Because remember, the judges care a lot about this right. And they're going to make the government demonstrate that whatever the governmental action was, could have been a law, could have been something else, it's narrowly tailored. First of all, necessary, narrowly tailored to achieve what kind of a governmental interest? A compelling governmental interest. So when the judges care deeply, when they care a lot, they're going to apply this strict scrutiny. They're going to scrutinize this law, and if it's not narrowly tailored to achieve not just an important interest, but a compelling governmental interest, it's going to be overturned, right? So strict scrutiny oftentimes means the government loses, because it's very hard to meet this high standard. Not always, but most of the time. So does the court care about this right a lot, a teeny tiny bit, or maybe somewhere in the middle? That's what we're after. So in quasi-suspect classifications, let's say we had a male and female, we were going to allow females to do something but not males. Well, you don't have to show a narrowly tailored action that was meant to achieve a compelling governmental interest, but you have to do something almost as difficult, right? Because the judges care deeply about suspect, or rather quasi-suspect classifications, and when you discriminate based on sex. And so they're going to apply an intermediate scrutiny, and that is going to be substantially related to an important governmental interest. Now, I'm going to highlight this here. Compelling governmental interest versus important, right? So it's easy to remember. Strict, use that hard C, and compelling. And then intermediate has important, right? It's just an easy way to remember. We're looking for important governmental interest, not a compelling governmental interest, an important governmental interest. And it's not necessary and narrowly tailored, it's substantially related. So it has a relation, but not just a rational relation, it's substantially related. And then finally, sort of, law is neutral on its face, but law has unintended racially disproportionate impact, maybe, or I would say if this has to do with your right to work, your right to not lose your property, something like that, it'd be a rational basis test. So the government action must be reasonably related to a legitimate governmental interest. And that's really easy. The government cares, but doesn't care a whole lot. So any rational basis put forward is going to get you where you need to go. Or in this case, the way we have it articulated is governmental action must be reasonably related. As long as it's not a crazy person giving testimony about how this is related, it will probably fly. So if you have a third tier, the government barely cares about this right, it's really easy for the government to win. When you get to intermediate scrutiny, it's not sort of the middle point between the easiest level of scrutiny and the most difficult. It's not necessarily the middle point, but it is in between. It is much closer to strict scrutiny than it is to a rational relationship test. It is much closer to strict scrutiny, but it's a bucket in the middle, and there's all sorts of things that get thrown in there. So let me tell you how this works in real life. At least let me give you an opinion about how it works in real life. Oftentimes, judges who are trying to decide cases, before they get to the merits of the case, they have to decide what level of scrutiny. So in appellate cases, we ask, what is the standard of review? And standard of review wins or loses cases all the time. So what standard are we going to apply? What level, in this case, of scrutiny? How much does the court care? And so the attorneys on both sides of the V are often arguing, the plaintiff is arguing for strict scrutiny, and the defendant, the government, is arguing for rational relationship, right? Very easy to win for the government, very hard for the plaintiff to win. Whereas the plaintiff is arguing for strict scrutiny, very hard for the government to win, very easy for the plaintiff who has been harmed to win, right? Because the government cares, rephrase that. The judges care a lot about their rights when they're applying strict scrutiny. They care a lot about strict scrutiny. They care deeply about intermediate scrutiny, and they don't really care a whole lot. I mean, I realize I'm trying to be a little facetious. So they don't really care a whole lot about rational relationship. Like, okay, you got a rational reason, it's reasonable. Okay, good, it passes the test. Intermediate scrutiny, well, we actually deeply care about that one. You're going to have a substantially related. Or your goal, your law, or your action must be substantially related to an important governmental interest. Like this important governmental interest, you're going to have to articulate that. You're going to have to show me how this law or this action is substantially related to it. And then when they really deeply, deeply care a lot, they're going to force the government to show a compelling governmental interest in how the action of the law was narrowly tailored. Like it was just, they did just what was necessary, nothing else, to achieve that compelling governmental interest. So what judges will do, I think, my opinion, oftentimes they will, in deciding which level of scrutiny to apply, they'll be, let's say, sophisticated about their response. A judge might say, well, you two are arguing about the level of scrutiny. You want rational relationship, you want strict scrutiny, fine. But even if I look at this case under intermediate scrutiny, the government can't win. I don't even have to apply strict scrutiny. If I merely apply intermediate scrutiny, the government can't win. So if that's the case, I'm not even going to decide whether or not strict scrutiny applies, because even at an intermediate level of scrutiny, the government can't win, and the plaintiff wins and they move on, and there's not some sort of holding or application of this very high standard. So that happens too. So I realize that you're reading this in your textbook, and you'll see these things, these standards of review or these tests come up. But I wanted just to take a minute to point that out. It really is important that you look at the definition. And when you see strict, you think compelling. When you see intermediate, you think important. And then rational relationship, I mean, if it's got a rational basis, it's reasonably or rationally related to a legitimate government interest, it's going to win. It's very hard for the plaintiff to win on those. It's very easy for the government. So oftentimes cases are won or lost on the application of the standard of review, or in this case, the level of scrutiny applied. So keep that in mind as you're reading through. I know that you're reading some long cases and you are feverishly looking through Supreme Court summaries and filling your brain up and then connecting the dots and drawing lines and creating a fantastic framework to understand the Constitution. So keep these things in mind, and I hope that you find these levels of scrutiny to be helpful in understanding what the court is doing and maybe why.